Where'd you get $75,000?
I worked on.
Okay, well, it's doubled to $150,000 now.
Look at me.
Are you David Lee Stevens?
Yes, sir.
I like your last name.
Strike.
One of us is misspelling it. Nonetheless, seriously, though, you were charged here with the second degree felony of aggravated assault with a deadly weapon, namely a knife. And that doesn't end there, because the indictment states that you were convicted in 2010 in Sutton County, Texas. Where's Sutton County? I'm not familiar with that. Is that up near Fort Worth?
Texas.
Huh?
Going toward El Paso.
Okay, it's what's the capital? What's the county seat of Sutton County? Yeah,
Sonora, Texas.
Sonora.
Yeah.
That's way out there.
Yes, sir.
Okay, it states you were finally convicted of illegal possession of a controlled substance, a third degree felony in 2010 out of the 112th District Court of Sutton County. So what this means is not good. Your second degree felony in paragraph 1, if you're found guilty of that, it can be enhanced or increased because of the previous third degree felony out of Sutton County, if that's accurate. So if all of this is proven true, you were looking at a first degree felony of no less than 5 nor more than 99 years confinement or life imprisonment, and a fine up to $10,000. So that is what you're facing here. The victim in this case, do you have any connection with this victim right now? Contact? The Keisha?
Yes, sir.
You're not supposed to.
I brought her to court so she could sign and let her know that it was untrue.
What was untrue?
The whole indictment.
That she lied?
Yes.
Well, that's a crime, isn't it?
Wow.
How many people are going to get in trouble on this? I don't like that. That's not the way the game, it's not a game that's played. State, she's the prosecutor. I know the way she thinks about this stuff. Lying doesn't get you out of trouble. Get you in trouble. What's his bond? You're not supposed to have any contact with people who are the victims, especially and changing stories. It isn't the way.
I know.
Isn't the way it's supposed to be. Well, no, you've had contact because you know too much about the plan that's being hatched to try to absolve you of responsibility. The law is not a gun. The law, it's about fairness and justice. I'm sorry?
His bond is $75,000.
Who posted that?
I did.
Where'd you get $75,000?
I worked on.
Okay, well, it's doubled to $150,000 now. Threatened to kill her with a knife, holding the knife in the hair. I'm sorry. When I'm speaking, you can't speak because the lady can't take everything. But this is what the lady said, the victim. You said, I'm going to effing kill you. Blood was observed throughout the house. A weapon was located. The victim stated the threat was taking place. She tried to gain control of the knife, cut her finger in the process. They located you, detained you. Y'all had been in a dating relationship for 5 years. 2 children. This isn't role modeling, for children. This isn't good role modeling for children. No, I'm still working on the probable cause affidavit. It's lengthy and detailed. Due to the nature of this call and the partnership, both were in agreement of the assault was, I don't understand what that word is. The assault was a result of family violence. The victim states she believed that you were capable of your threats and that he placed her in fear of imminent death. You were thus arrested, placed in the back of the patrol vehicle and transported. If the affiant believes if you and the victim were to be left alone, further family violence would ensue. That's why we try to work things to have no contact until we can resolve this. The defendant is charged with aggravated assault with a deadly weapon, second-degree felony. Okay. Condition of all bonds or don't have contact with the victim unless I authorize it. And I didn't. Here's the remarks of the magistrate when your bond was set. Remarks: no contact of any kind with the victim, Lakeisha Williams. Okay. It's $150,000 plus you have to have a GPS device. Plus you will stay in home confinement at someone else's location other than the victim until this can be sorted out. Next time there won't be a bond.
I never.
That you're gonna, y'all figure that out. Those are the court's orders. You're taken into custody. You don't make the rules. The law makes the rules. Okay, I'm looking at the memo under the setting. It says communication issues.
Judge, I received a phone call from the victim's
That's a form
dad.
of communication.
Yes. The issue with the communication is that the defendant's parent or parents have reached out to the victim's stepdad asking for a meeting of lunch or dinner to discuss this case.
No.
And I would like him to be admonished that that the defendant, he himself cannot contact them. And I'm asking that he not, and I can't prove that he had his family contact them, but that they can't contact them and know that victim's family does not want to be contacted.
Don't do that. Nor anyone on your, nor anyone in your van. Okay. Is that
They're co-grandparents, Judge. So there's a grandchild. So the grandfather contacted the other grandparents on the maternal side to discuss the child.
Just don't communicate about this case because it can be perceived as trying to influence this case. Okay, what are we doing on this though? It's set for trial?
Yes.
Okay, because it's over a year old.
It's
set for trial.
It's coming up soon.
All right, okay.
And Judge, I understand that they are co-grandparents and they may talk about the grandchild. My issue is them calling and saying, can we talk about the case? That should not happen. I'm not saying they can't talk about
Is that clear?
their grandchild.
All right. Okay, so get ready for trial in July.
No response.
Alicia Simeon, is that you? Are you? That's you? Oh, come on. 25C01739. On this one, what are we doing on that? Have you had a chance?
I spoke to her on the telephone, but again, there was no answer in the courtroom prior to court.
Okay,
If you'll hold on to it, we can maybe dispose of it this morning.
you're Alicia Simeon? Okay.
You just,
Are you aware that you're charged with this third-degree felony of theft, which carries with it no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed? Do you understand?
Yes, sir.
Where's the truck? Was it returned?
Yes.
Okay, you don't have it, they've got it, the people who own it.
Yes, sir.
Okay, that's the most important thing. All right,
if you just
tell me
hold it.
what y'all are gonna do. Okay.
We're gonna see that they're gonna finish here on visit with you. Don't leave the store.
Hubert, are you still, what'd you say you were doing on, Daniel Rodriguez?
I'm parking this,
Okay, I think I give you the problem. On. All right, now, you call 25 CR 1739, the state of Texas versus Alicia Simeon, present with Mr. Dusel, your attorney and the state's attorney, Douglas, the defendant. We have a formal reading of this indictment and the arraignment here. Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about September 17th, 2024 in Jefferson County, Texas, you committed the third-degree felony of theft involving a Ford automobile. Do you understand what you're charged with?
Yes.
If convicted of a third-degree felony, you face no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can also be assessed. Do you understand?
Yes.
I'm looking at an agreement that has been prepared by the parties, which state you would be pleading guilty and placed, stand by, passed right out. Be placed on deferred or unadjudicated probation, which can be up to 10 years in length. Most importantly, be ordered to pay restitution. What is was the truck ever returned?
I don't,
It says the truck was recovered in the 4100 block of Maida.
yes, I don't believe there is restitution.
I don't.
Has to be.
That's why I put to be determined that
I thought there's gotta be.
if the real agency is asking for something, we'll find out.
See, she rented it in July, and then it wasn't recovered until the following August 18th, with 5 weeks later. She was supposed to return it. She extended the rental and continued to pay the extensions until July 23rd. Okay, so it would be, according to this, a period of time, July 23rd through August 18th.
Yes,
Usage that was, so it'll have, we'll do a post sentence report and determine what the restitution will be, if any. And there would be terms and conditions of probation, which are normal and customary for this. Is that your understanding of the plan?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead in this charge, ma'am? Guilty or not guilty?
This is another huge moment. Everything that follows depends on the answer you're about to hear, and the judge's response may surprise you.
I'm sorry. Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes.
I'm going to show you what's marked here as State's Exhibit 1. Did you sign this document? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into
No,
evidence
sir.
without objection. This states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. What you've been charged with, the indictment's been read to you. You were guilty to find charged in any lesser included offenses. You're giving up your rights to a jury trial and the rights to the apparent confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
If nothing further, I will follow this agreement and find you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, but I'm not going to do that. I'm going to defer or postpone any finding of guilt so long as you follow the terms and conditions of probation. If you fail, your probation can then be revoked. You can be found guilty and sentenced up to this full range of punishment. This will be for a 10-year period, but you pay restitution back and I can end it in a third.
Yes.
Have you ever been convicted of anything before? All right. 5 years term, and again, pay this restitution back and we'll get you out of there in a third. Do you understand what has happened tonight? Probation officer will prepare the probation report, we'll sign it, and you'll begin probation. Thank you.
And just like that, two very different courtroom stories reached two very different outcomes. One defendant lost freedom after ignoring the court's orders, while another was given a chance to avoid a conviction through probation. Which decision stood out to you the most? Let us know below.